All right, welcome back. It's been a while since I've done a video specifically on the Alec Baldwin trial. Frankly, I think the last video I did dedicated to Baldwin was when the charges were first brought. And then they were dismissed, and then they were brought again, and they've been at trial all week. And the case has been dismissed with prejudice by the judge. It frankly is quite shocking. It's yeah. So for those of you who are new, I figure I should introduce myself. Hi, I'm Joe. I'm an attorney. I'm licensed to practice in the state of Utah. This case is was in Santa Fe, New Mexico. So kind of a neighbor, kitty corner, four corners, all that. But yeah, so after the marathon that was the Karen Reed trial, I wasn't up to live streaming this entire trial. It's a lot of work, takes a lot of time, a lot of energy. It's exhausting. So I was going to ignore it. But then I've mentioned multiple times how I'm uneasy with the case. And that stems from, there are rules. You never point a gun at something you're not okay with killing. You just gun safety to me was not followed. But at the same time, I had a real uneasiness with this case because part of the reason you have an armorer on film sets is gun safety is their responsibility. And to me, the armorer being negligent, and the armorer, Hannah Gutierrez Reed, now goes just by Hannah Gutierrez, I believe, has already been convicted. But to me, it's an intervening, unforeseeable act from Baldwin. And I really had an uneasiness with assigning guilt to him. Even, even if I believe he was irresponsible, it just it gave me the ick. But Baldwin being a producer on the movie on Rust, and the producer being liable, the producer being responsible, I should say, for hiring the armorer, hiring an irresponsible armorer, an inexperienced armorer, an unqualified armorer. To me, that was, at least to settle the queasiness I felt, the better theory of a manslaughter case against Baldwin. But I almost made a video on this at the beginning of the week before the trial started because basically that was off the table because there was a pretrial ruling that was brought that um, the prosecution couldn't mention his role as a producer. That was suppressed. And I thought, his chances of winning this have gone up. His chances have gone up. Well, turns out his chances went way up on Friday morning, Friday afternoon. I don't know what time it happened, but a witness was testifying, and they testified about an amended report, which the prosecutor had not provided to the defense. Now, I don't know the full details of the report because, frankly, I don't really care. The details of the report aren't what's important here. But the gist of it is there was a guy, can't remember his name, once again, don't care, but he was concerned about the safety on the set, and so he apparently was trying to um, prove a point that he could sneak live rounds onto the set or something, and then there was like I think it was him. Once again, I'm not sure. I don't care. Excuse me. But went to law enforcement with information about bullets that could have been exculpatory to Baldwin. Could have been. I'm not saying it was. It could have been. And prosecution, and by prosecution I mean law enforcement generally, engaged in fuckery. And in order to hide it, because under Brady versus Maryland, well, number one, you have to hand over what you're going to rely on. The prosecution does. But you also have to hand over exculpatory evidence to the defendant, to the defense, even if you don't plan to use it at trial. Because frankly, if you're the prosecution, why would you use exculpatory evidence? Exculpatory evidence, of course, meaning it tends to disprove the defendant's guilt. So, in order to hide it, they logged the evidence, they logged the report under a separate case number. So, even Baldwin requesting all evidence under this case number, it wouldn't turn up because it's a separate case. But that witness today on the stand disclosed it, and it's during trial. So jeopardy has attached, meaning if a decision is, if not guilty had come in, he couldn't be retried. Now, you if this has been discovered before trial, there may have been another remedy, sanctions against the prosecution, some sort of adverse inference, some sort of, evidence suppression. But here, it's in the middle of trial. And that's bad. That's really bad. So Baldwin brought a motion to dismiss, and spoiler alert, the judge granted it. So the judge dismissed the case with prejudice, meaning it can't be brought again. It's gone. It's over. And this really pisses me off. Now, hang on a minute, you're going to say, Joe, you just said this case gave you the ick. And now you're mad that it's been dismissed with prejudice on a technicality. Well, the U.S. Constitution isn't a technicality, but we'll leave that. But yeah, and it's not the judge dismissing it that pisses me off. The judge made the right call. It's from the start, it has seemed that the prosecution has played games. Now, I haven't followed the case closely enough, so I can't tell you every stop away along the course of the trial that I've thought, "Ooh, they're playing games. This is messed up." Um, Part of it though, the special prosecutor they hired was problematic. But if a decision is going to be made, I want it to be made on the merits. I like whether Baldwin is guilty or innocent should be decided on the facts. But because the prosecution engaged in fuckery, insurmountable fuckery, it can't. And that makes me mad because number one, if they had to resort to fuckery in order to feel like they'd win the case, they shouldn't have brought it in the first place. So if you have to cheat to win as the prosecution, justice would require you not to bring the case, even if you really, really, think he did it. You really think he's guilty, but you can't prove it without playing games, then justice says you don't bring the case. If you think you can prove it, it should be decided on the merits because that is justice. For Alec Baldwin, it's justice. For Halyna Hutchins and her family, the victim in this case, it's justice for the state of New Mexico, the citizens. But because law enforcement and the prosecution engaged in fuckery, there is no justice. There's no justice. It's just the end of a case. And if that feels like a letdown to you, it should. It really should. And I don't like it. Even though the judge made the right decision. Now, before we watch the video, and oh yeah, two points before we watch the video. So the prosecutor said, well, we decided it wasn't relevant evidence. That's why we didn't hand it over. Well, relevance isn't for the prosecution to decide. Because, like I said, if it's exculpatory, if it's even possibly exculpatory, you hand it over to the defense. And if it's exculpatory but not relevant, you hand it over to the defense, and then you bring a motion to suppress. Let the judge decide that it's not relevant. It's not for the prosecution to decide. The defense doesn't get this because it's not relevant. Therefore, we don't have to hand it over. That's playing games. That's fuckery. That's not justice. You bring a motion to eliminate. You bring a motion to suppress. You let the judge keep it out of the trial. You still have to hand it over to the defense. Now, does this mean the case is really, truly 100% over? Probably. But I have seen dismissed with prejudice overturned on appeal. Now, this is a little different than the case I saw that in, and I haven't done exhaustive research on it. And in fact, I haven't done any research on it because I don't care enough. But the case I saw it in, one of the differences, it was in federal court here in Utah. This is actually one I was sitting in the courtroom when it was dismissed with prejudice. It was when I was doing my internship with the U.S. Attorney's Office in the white collar division. So there's a Ponzi schemer here in Utah by the name of Rick Korber, who ran a multi-$100 million Ponzi scheme, and he was really high profile. You drove on I-15, you'd see billboards of him in his Ferrari, basically touting, yeah, I'm real Mormon, and because I'm such a devout, godly Mormon, God has blessed me, and he'll bless you too if you invest in me. What was the gist of his advertising? I'm serious. It was gross. And, well, his Ponzi scheme was real estate based. So the 2008 2009 real estate crash exposed his Ponzi scheme. And he was charged, and he played games and delay after delay after delay after delay. And finally, in summer of 2014, the judge dismissed the case with prejudice on speedy trial violations. Now, the problem with that is he had been the one asking for the delays. But the judge held that against the government. And part of the fallout from that, of course, is as we were walking back to the office, one of the young assistant U.S. attorneys, that they give breakdowns to us as interns, said, well, going forward, I'm just going to indict when I'm ready to go to trial, so long as the statute of limitations isn't a problem, because we didn't need all these delays. The defense did, but because we couldn't account for all the days, it was held against us. So we're just going to indict and say, yep, we're ready for trial, because they build their case before they indict. Well, the 10th Circuit Court of Appeals said, no, Judge Waddups, you calculated this wrong. You, frankly, are way too anti-government, and reversed on appeal and sent it back to the federal district court, and Korber was later on convicted, and I'm pretty sure he's still in prison, assuming he's even still alive. I mean, he was fluffy. He was very fluffy, and I can't imagine he's had a enjoyable time in prison. So yeah. But with that, let's watch the judge listen to her reasons for dismissing with prejudice. As she's going to say, it's an extreme remedy, but it was the right one here. So
dismissal with prejudice is a very extreme sanction. And case law is very clear that because it's very extreme, I have to go through every single element, and I have to make a very good record as to why I'm seeing what I'm seeing. So in order to establish a Brady violation, the defendant must show that the prosecution suppressed evidence, the evidence was favorable to the accused, and the evidence was material to the defense. So let's go through the elements. Suppression of evidence. The definition of suppression of elements, this is Case versus Hatch, is while the first element requires proof that the prosecution suppressed or withheld the evidence in question, it does not require a finding of bad faith or any other culpable state of mind on the part of the prosecutor.
So it doesn't require a finding of bad faith by the prosecutor. Here, though, I'd argue it's an extremely bad faith, if not by the prosecutor, by law enforcement in general, because assigning a separate case number to keep it hidden, that's bad faith if I've ever seen it. I mean, frankly, heads should roll for this.
This prong is satisfied. The Santa Fe County Sheriff's Office and the prosecution failed to disclose the supplemental report to defense and provide defense an opportunity to inspect the rounds collected into evidence that Mr. Teskey gave. Is the evidence favorable to the accused? The second Brady element is whether the suppressed evidence was favorable to the accused, either as impeachment or exculpatory evidence. This prong is satisfied. The suppressed evidence is favorable to the accused. It is impeachment evidence, has even been offered in this trial as impeachment evidence, and is potentially exculpatory to the defense. Critically, the exculpatory value cannot be analyzed at such a late juncture because of the non-disclosure.
And that's, as I said, at such a late stage, in trial, what's the defense supposed to do? Go home after court that day and analyze it? Find an expert? You can't do it. You just can't. Ask for a pause of the trial? No, you dismiss. Had it been discovered earlier by the defense, there would have been remedies available short of dismissing with prejudice. Like I said, a delay in the trial, of course, that could run up. Well, I'm assuming Baldwin waived speedy trial. I don't actually know, but.
Is the evidence material? While post-trial discovery of evidence under Brady requires a reasonable probability that the result of the proceeding would have been different, discovery of evidence during trial requires an evaluation of whether the late tender has impeded the effective use of evidence in such a way that it impacts the fundamental fairness of the proceedings, and that is State versus Huerta Castro. This evidence is material. The late discovery of this evidence during trial has impeded the effective use of evidence in such a way that it has impacted the fundamental fairness of the proceedings. The defense is not in a position to test the state's theory as to the source of the lie.
Fundamentally unfair. Here on this channel, we call that fuckery.
Rounds that killed Ms. Hutchins. I'm also going to take a look at Harper. State versus Harper. The assessment of sanctions depends upon the extent of the government's culpability, weighed against the amount of prejudice to the state, quoting Chenard. Let's go through culpability. Our case law generally provides that the refusal to comply with a district court's discovery order only rises to the level of exclusion or dismissal where the state's conduct is especially culpable, such as where evidence is unilaterally withheld by the state in bad faith, or all access to the evidence is precluded by state intransience. The state is highly culpable for its failure to provide this discovery to the defendant. The state unilaterally withheld a supplemental report. Santa Fe County Sheriff's Officer made the decision, and apparently also with the prosecutor, as pursuant to Hancock's testimony, that the evidence was of no evidentiary value and failed to connect the evidence to the instant case. The case agent, as well as pursuant to Hancock's testimony, Ms. Morrissey, was aware of the new evidence and yet did not make an effort to disclose it to defense. The state's willful withholding of this information was intentional and deliberate. If this conduct does not rise to the level of bad faith, it certainly comes so near to bad faith as to show signs of scorching.
I like that. I like that. The prosecution's pants may not be on fire, but she's such a liar, that they're definitely singed.
Prejudice. When discovery has been produced late, prejudice does not accrue unless the evidence is material and the disclosure is so late that it undermines the defendant's preparation for trial. The court concludes that this conduct is highly prejudicial to the defendant. The jury has been sworn, jeopardy has attached, and this disclosure during the course of trial is so late that it undermines the defendant's preparation for trial. There is no way for the court to right this wrong. Lesser sanctions under Harper. Trial courts possess broad discretionary authority to decide what sanction to impose when a discovery order is violated. State versus Lemire. The sanction of dismissal is the only warranted remedy. The jury has been sworn, jeopardy has attached, and a mistrial would not be based upon manifest necessity. Further, the sanction of dismissal is warranted in this case. The state has repeatedly made representations to defense and to the court that they were compliant with all their discovery obligations. Despite their repeated representations, they have continued to fail to disclose critical evidence to the defendant. Brady and Harper are satisfied.
So basically, right there, the state has numerous times asserted to the court that they have completed discovery, that they disclosed everything. That's a misrepresentation to the court. Heads need to roll.
Dismissal with prejudice is warranted. Court also has power, inherent power. Per State versus Lemire, where discovery violations inject needless delay into the proceedings, courts may impose meaningful sanctions to effectuate their inherent power and promote efficient judicial administration. The state's discovery violation has injected a needless, incurable delay into the instant jury trial. Dismissal with prejudice is warranted to ensure the integrity of the judicial system and the efficient administration of justice. Your motion to dismiss with prejudice is granted. Now, with respect to the jury, I don't imagine you all want to return on Monday. I will take care of the jury.
Thank you.
All right. So basically, the jury was out of the room for that. They were in the jury waiting room, and the judge is like, yeah, so I've still got to dismiss the jury on Monday. Frankly, they probably actually sent the jury home for the day. So she's like, yeah, I've got to dismiss the jury. You guys don't have to come back for that. I will do that on my own. And it's like I said, this is egregious. Does it rise to the level of disbarment? Not necessarily. Does it rise to the level of suspension? Maybe. Especially the misrepresentations to the court. That contempt, I could see it. Now, this isn't the only case, though, because Hannah Gutierrez has already been convicted. Now, I don't know if this was disclosed in her case. I don't know that this report existed during her case. I don't know that this evidence could have been provided. You'll notice, though, the judge did say Brady violations have a different remedy after a trial than they do during a trial. So let's say, and this is the same judge from the Hannah Gutierrez trial. Let's say Hannah Gutierrez brings a motion for a new trial, a motion to throw out the verdict, a motion to dismiss. At the very least, an appeal, but she could bring a post-trial motion to this judge. Now, once again, I don't know that it's relevant in her case. I don't know that a Brady violation occurred in her case. But if I'm her lawyer, I'm really looking into it. I'm looking at this saying, wait, what? Huh? What's going on? This affects me how? What can I do with this? But once again, with her, since it's after trial, even if there was a Brady violation, it might not necessarily mean dismissed with prejudice. Although, in the interest of justice, it might, because if Baldwin was dismissed with prejudice, maybe Gutierrez needs to be as well, just in the interest of justice, you know, equal justice. Of course, their culpability is also based on different theories. They're, you know, different overt acts. Now, the assistant director, can't remember his name. Once again, don't care. Haven't followed the case that closely. He entered a plea deal 2 years ago. He probably doesn't have an appeal right because, well, frankly, he pled guilty to a lesser charge, 6 months of probation, I think, and he was done with it. So there probably is no appeal there, to the extent he even has an appeal right, because pleading guilty, most of your right to appeal is waived. So, yeah. But either way, like I've said, this case, at least as far as Baldwin goes, gave me the ick from the start. I'm not saying he wasn't guilty. Well, he's not guilty. I'm not saying he couldn't have been guilty. I'm not saying as a juror I wouldn't have found him guilty. But it gave me the ick. This today, well, yesterday, I'm recording this after midnight, is the right decision, but its necessity pisses me off. And it's just, when you have law enforcement playing games, hiding the evidence, assigning different case numbers to hide the evidence, when you have prosecutors co-signing that fuckery, you don't have justice for anyone. And that pisses me off the most. That pisses me off the most. So that's, you know, that's the moral of the story today. Don't piss me off. Don't engage in fuckery unless it's consensual. Then we don't kink shame. But do all the YouTubey stuff, like, share, subscribe, bribe your friends and family to do the same, and I will see you next for the start of getting caught up on the TikTok psychic lawsuit. So yeah, thanks for joining me. Bye-bye.